Good afternoon. It is the last Sunday of August 2017 and also the 7th anniversary of the 2010 Constitution, and a very eventful afternoon. This afternoon, the hearing of the biggest and most important case in the country right now begins. The 7 judges of the Supreme Court will hear arguments from Raila Odinga's legal team as they challenge the declaration of Uhuru Kenyatta as president-elect. Across the street from the Supreme Court, principals of the National Super Alliance, NASA, are attending service at the All Saints Cathedral as they plan to hold what they call a vigil outside the court alongside their supporters. Of course, security is tight around the court. Police have warned against any such gathering. We have our reporter, Sophia Wanuna, whom I'll be going to in a moment. We'll also be speaking to Mark Namaswa later on from All Saints Cathedral. But let's start with Sophia, who is at the Supreme Court. Sophia, a lot of things expected this morning. Actually, as a matter of fact, at 10 a.m., there should have been something at the registry. The CJ had promised that they would actually have summarized and teased out the issues that will be discussed or the ones that are going to be argued over by the lawyers by 10 a.m. Is there any sign that anything like that has happened this morning?
Well, afternoon, Joe. Not yet. That is yet to happen. We have been at the registry and speaking to some of the judicial officers. It is true what you just indicated. Yesterday, the Supreme Court judges had said that by 10 a.m. they would release those issues, the questions that would actually come before the court for deciding, for ruling, and what we'll be hearing on in as far as the arguments from the petitioners, the respondents, and other parties that may be granted permission to be part of this case. But as for now, not yet. The questions or the real actual issues that will come before the 7 judges for determination are yet to be made public. And remember, the court or the judges are deciding upon these issues because the parties were unable to. They had occasion to do that. They had a meeting of the various lawyers, the petitioners, of course, who had 24 issues that they had outlined. The first and second respondent had 2, the third 2 issues as well, but they could not agree because the rules allow for them to sit down, deliberate, and agree on what they see as the most important and key issues for argument and determination. So now it's the judges that must decide, and we're yet to see what that decision will be, Joe.
Any indication when that might happen? And just to clarify to our viewers, you mentioned the reason why the judges have to do this is because the lawyers themselves couldn't agree in court about what those issues really are.
Yeah, it's unclear at this point. It's something we keep following up on because remember, even yesterday, towards the end of the court session, we saw the petitioner and the first and second respondent asking that the proceedings or hearings begin tomorrow because, of course, after those issues come out and as well as the ruling on the applications that had been made, they had argued that could have an implication in as far as how they'd organized their presentations. But the judges were adamant because of the strict timelines they wanted to start today. But as we stand right now, Joe, unclear at what point these issues will be made public or will be communicated to the teams. We have been in touch with the various counsel. As for now, they are yet to receive the same. But that must happen before 2 p.m. because, Joe, at 2 p.m. we'll be having a ruling on the 8 applications before the Supreme Court. 4 of those applications are for parties seeking to be enjoined as friends of the court, and the other 4 are for those who want to be enjoined as interested parties.
So, Sophia, let's go a little bit systematically about those 8 rulings that are expected. From NASA, what exactly do they want the judges to rule on today?
For NASA, remember when they were submitting or presenting their written submissions, they also made interlocutory applications, which in essence are interim applications before the hearing proper commences. And one of those they had applied is to have the responses from the first and second respondent kicked out. And we had a lot of that in terms of submissions from counsel for the petitioner as well as the respondents. And the argument by NASA is, while whilst the first and second respondents were able to file their written submissions by 11:30, which was about half hour before the deadline, midnight, and as far as filing those, serving them rather, as the petitioners, they were not able to do so by the midnight deadline. They served them the following day at 3 p.m. However, the first and second respondent, that's IEBC and the IEBC chair, argued that when they sought to serve the petitioner with the written submissions, their offices were closed, and so they did not know what to do. And yet, we're talking about that every party was needed to avail themselves for actual service. So that is one of the areas we'll wait to see whether the judges will agree with the petitioner or with the respondent in as far as those written submissions are concerned. And then as well, you have NASA wanting an audit, okay? They want to audit the systems of the IEBC. The logs specifically is what they've talked about. And that made a bulk of the arguments we heard last evening during the pretrial conference. Because at first, counsel for the two petitioners, that's Raila Odinga and Kalonzo Musyoka, argued that first they needed to go through the original Forms 34A, B, as well as C. He went on ahead to, show to the court what they had realized or noticed as discrepancies, and as far as the security features are concerned on those documents, that if you print out, you couldn't get the other. But Joe, what was interesting and perhaps got all parties off guard is when we had counsel for the first respondent, that's IEBC, saying that in fact they were willing to supply and make public this particular documents, that the petitioner had gone to a large extent to showcase and explain why they needed those original forms. But then we had Paul Mwite, who is senior counsel representing the IEBC, saying they had no problem with these forms being handed to the petitioner. And so after that short adjournment, quite the wind here, forgive me. After the short adjournment that was taken in the courtroom, then we heard senior counsel James Orengo switch gears and focus more on the logs, on the audit of the service for the IEBC. The IEBC arguing, and the first and second respondent, that it would take at least 3 weeks for that to happen. But the petitioner counter-argument was that they're not asking for the physical service, they want access. And they had to really explain to the judges, because on one hand, the petitioner saying they need perhaps 2 or 3 hours to do that. IEBC saying it would need about 3 weeks, and that also they'd be concerned about the security of the system thereafter. So those are some of the prayers that we are seeing the National Super Alliance, of course, the two petitioners, Raila and Kalonzo, seeking, and we'll see if they'll be given that access. If they're given, for how long, how will it be conducted, and more importantly, how does that information then, Joe, make it back into the proceedings? Because if it is as evidence, there's those who would argue it is out of time, as we had some of the counsel say, or in what fashion or form then it would make it back, Joe.
Very interesting, Sophia. I'll not ask you whether the server will be brought there or whether the cloud will come down or anything. Quite interesting scenes in court last night. But there was the issue of the Attorney General. I mean, he wants to be amicus, but he seems to have been playing, or at least attempting to play, a certain role in that court. I have to say, of course, that the judges didn't seem to give him a lot of time to do whatever that other role was. Do we know where the AG stands? Other than this application to be amicus, does he hold any special place in these proceedings as you understand it right now?
Joe, as we understand it, of course, as the Attorney General of the Republic of Kenya, he has that standing in as far as the legal fraternity. But in this particular matter, the rules and procedures must be followed. So there, in essence, isn't any special treatment. It all comes down to the amicus brief that he filed before the Supreme Court, what the judges will consider, what he's arguing in his brief as in terms of the information he's seeking to bring before the judges pertaining to this case that he would be arguing has bearing on the same. Of course, he should not be seen to be favoring any of the parties. But his application to be amicus curiae is one that has been opposed by the petitioner. And we saw a little bit of that exchange yesterday when he sought to address the court, and as Attorney General and the lead counsel for the petitioner, James Orengo, stood up and quickly, addressing the judges, said that he was not yet an amicus curiae, so he was not yet a party to this. So already we can see some of that exchanges. So we wait until the 2 p.m. That is when the judges will actually deliver the ruling on the applications, those on the amicus curiae for him and the other 3 parties seeking to be friends of the court, as well as those that want to be enjoined as interested parties. But also, you note later on, the Attorney General stood towards the end of the proceedings last evening, seeking to advise the court on the way forward, that perhaps they could today just send the rulings via internet and not necessarily sit down to rule on the same, and then give one day to the petitioners to make their submissions, and the next day to the respondents. However, we saw a very firm Deputy Chief Justice answer him back and say they are well in charge of the proceedings and they would be giving guidance as and when needed.
Yeah, actually, I'll be discussing that bit with my guest later on about thanks but no thanks. That was quite interesting. But Sophia, let's speak a little bit about the politics of this. I understand that NASA has been planning this vigil. We'll be speaking to Mark Namaso in a moment because some of the principals are at All Saints Cathedral right now. But what is the situation around the courts with regard to that? Because the security had been tightened seriously yesterday, and NASA had said they would hold some kind of prayer or whatever that was. What would you say is the situation there with regard to that?
Indeed, Joe, in fact, with me here outside the Supreme Court is what we are calling the advance team for that NASA team. We understand they're set to head this way. As you said, quite a tight security setup that has been put here. On the 3 roads leading to the Supreme Court, they have been cordoned off. There are tracks with barricades on them. So in as far as traffic, that's vehicles, they're not allowed to this side. But so far, there's a little bit of human traffic just making their way in and out around this premises. But joining me now is Simba Arati, who's Dagoretti North Member of Parliament, and he tells me he's come to make sure everything is in order and that they actually intend the rest of the NASA team to come here after the prayer service they're attending. So let me speak to him just now. And Mheshimiwa, thank you for making time for us here on KTN. So you intend to hold prayers, is it?
Indeed, we're intending to have prayers, what we call vigil, around the courts here. Of course, we don't expect to be going in, but we are certain that if you're seeing people walking around here, these are the people who are prepared to come. Of course, as you indicated, I've come to assess the situation because the principals, they are coming in, and all other leaders. We expect, including even our brothers from Jubilee, if they want to pray for our country, they can come and join with us outside the Supreme Court. We saw this one happening at ICC, where the president with his entourage were outside the courts, singing, praying. We saw the governor-elect, Nairobi, abusing even some judges in the ICC. Therefore, we don't see anything wrong as having the vigil outside the Supreme Court.
However, the commandant in Nairobi County has given a directive that if there are to be any vigils or prayers, they should not be within the vicinity of the Supreme Court. They can be elsewhere, and yet hence the cordons around.
You know, old dogs don't learn new tricks. Koome is an old school man, and we're not going to be intimidated by him. We want to tell him that he has to go back to the Constitution, understand what the Constitution requires of us. We are not in a primary school. Kenya is a country. Therefore, we want to tell him that we will meet. He likes it or not, we will meet. If he wants to beat people and kill them the way he has done before, we are ready to meet him.
Allegedly, those are serious allegations you're making on live television.
His officers in Nairobi killed our people. Therefore, we are not going to let him go. We want to warn him that we are not protesting. There is no chaos. Therefore, unless he wants to cause chaos himself as the commandant of Nairobi, we can't allow him to cause chaos.
But why pray here? Why not elsewhere?
It's a tradition. Also is to ask God, the Holy Spirit, to come closer to Parliament, guide those people, so that they are not actually also compromised. We saw 2013 judges who were compromised. We hope that the Holy Spirit, and that's why we have decided to have it here. We have it here at court. We pray God to give them wisdom. Either way, if Uhuru gets it, well and good. If Raila gets it back, we'll say hallelujah.
Don't you see this as antagonistic, your move to come here, in as far as there's an order from the police? Number two, for the environment around the court, and it's before the judges and the parties who will argue the matter.
I want to tell you, there is nothing that jeopardizes the process, because what happens is we are looking at, traditions all over the world. When people want to express, and especially with us, what we are doing is we are doing prayers. If it was chaos, causing chaos around and wanting to go into the Supreme Court, therefore that's a different thing. They are saying we want to intimidate the lawyers. I want to repeat myself. When the president and the deputy president, they had a case at ICC, were they intimidating the judges at ICC? And they used even taxpayers' money. Here, we are not spending any taxpayers' money in coming and praying around here. We're asking even our colleagues from Jubilee, if they are willing, they can come and join with us in the prayers.
Finally, where exactly will this vigil be? Will it be within this cordoned-off area, or will you be outside the cordon?
No, we intend to have it here, where and we expect the police to provide security the way they are doing. We don't intend that these vehicles are going to intimidate anybody to come in. We expect that the prayers, of course, would have expected them even to inspect the people who are coming into this square, the Supreme Court square, for us to continue with the prayers. We'll do it tomorrow, and actually we want to ask every Kenyans who want for our country to go peaceful and have either a real which is peaceful to continue and gather together. We make sure we have prayed for our country, and we want to ask every party involved to join us in the prayers.
So what time are you coming?
Shortly, the principal, they are in charge. Of course, they are finishing the morning service. The midday service will be done here.
All right.
Yeah.
Many thanks. Simba Arati, Member of Parliament, elect Dagoretti in North, talking to us there about the plans, Joe, to have that vigil. And they say it will be within this square. And perhaps I can quickly just take you through, if we may, just around the security here outside the Supreme Court. On my right, you'll see towards the end there's a police truck, sir, if you don't mind. Just give us some room. There's that cordon. And, of course, you can see it's a truck in the middle with a mesh on both sides. So, again, with officers around there. And then we want to go around to this other side. If you don't mind, I'll just quickly cross as one interview is going on there. So, again, on this side, Joe, 360 security, another of those trucks, another cordon as well, police officers, security officers around here as well. And finally, to the other side of City Hall, where you will be seeing that shortly. Yet again, another track with cordons on both sides, just ensuring, and as far as vehicles, no one can come here. And of course, on the front side is the Supreme Court, and that is where attention will continue to be later on this afternoon at 2 p.m. when we expect the decisions on the rulings on the applications, and at 3 p.m. the hearing proper begins. And Joe, also maybe to quickly mention before I hand it back to you, we have been able to get a copy of that letter by the registrar of the Supreme Court. Remember, during the proceedings yesterday, the respondents were also arguing to have several affidavits by the petitioners kicked out of these proceedings. And that the basis was that they were filed out of time, and that in fact they had acquired one of the clerks, quote unquote, to be able to backdate those affidavits to read the 18th. That's the day the petition was filed, and yet they were filed 2 days later. So apparently, according to IBC and the IBC chair, the first and second respondent, they were saying those affidavits should be thrown out, should not be part of these proceedings because they were actually filed out of time, and that it was, quote unquote, an illegality to have an officer at the registry seek to backdate the same. Joe.
All right. Thank you very much, Sophia. Obviously, we'll be waiting to see what happens around there. So just finally, before you go, I take it that City Hall Way, and that looks to me like Wabera Street as well, is basically out of bounds, so that people who are coming to work maybe tomorrow should look for other ways of accessing whichever place they are going to.
We will seek to get that confirmation as far as those accessing their workplaces, because there's supermarkets here, like Nakumat, for example, is open. There are people going in and out, and as far as shopping is concerned, there's a Java store shop here as well, restaurant, it is open. People have been able to move around. Human traffic, that there's no problem on that. I think they will be able to carry out the activities, but we'll get a confirmation. Yes, you cannot drive through this particular location, Joe.
All right. Thank you very much, Sophia. I can see some people doing a bit of, I don't know whether that is wheeling, driving, riding, whatever it is. But thank you very much, Sophia, for that comprehensive update. We'll be coming back to you in a few minutes as we continue to get updates there. As I promised, we'll also be going to All Saints Cathedral to try and speak to Mark Namaswa, who is at that service that's being attended by the NASA principals. I have seen Raila Odinga, Kalonzo Musyoka, Moses Wetangula, and we'll be just finding out in a few moments just what is going on there. But right now, I want to introduce my guest. Dr. Linda Musumba is not a stranger anymore to this conversation that we're having about the Supreme Court. She's a senior lecturer at Kenyatta University, the law school there. And Daktari, let's just start this from where we must. Last night, a very long session there, and many Kenyans were quite confused about what was going on. Pretrial, status conference, interlocutory applications, rulings, all manner of things going on. In a nutshell, what were these lawyers arguing about for all those hours? What were these things that were before the court, and how do those things relate to what we now understand is the main petition?
Thank you, Joe. Yesterday, what we had was what I would call housekeeping issues before the case begins. Housekeeping to be able to determine who the parties are, what are their initial or preliminary, preliminary concerns that they may have, what are the things that they want, having looked at each other's pleadings, what are those things that come to their mind for which they would like the court's early attention, so that when the main petition begins, it proceeds without any ado. I think one of the things that definitely must be realized in a case such as this, and in the history of our country, we've had these sorts of cases beamed in our living rooms. We had the one of Charles Mugane Jonjo. We had the Robert Ouko trial. And then we've also had, of course, the 2013 case, that these trials also take place in the living rooms of people. And therefore, people do need an understanding of what is going on. So at least for the public to be able to understand that those were really housekeeping issues. We saw issues such as the petitioner requesting the court to be able to strike out some documents that the respondents have put in court. We saw amicus curiae, those who want to be able to appear as friends of the court, making their applications.
But Linda, those sound like serious things. I mean, by the time someone is applying that this thing I have filed in court should be struck out, that's more than housekeeping. There's something that there's an impact it might have somewhere down the road, right?
Oh, certainly, of course, it's likely to have an impact down the road. But let's remember that there is the main petition, the main thing that is being alleged or put, on the table by the petitioner. And before the court is able to properly look at this matter, these are the preliminaries that must be dispensed with. So, for example, if we were to draw reference in the 2013 petition to avoid going into, of course, the issues of the 2017, we saw that the petitioner at the time, Raila Odinga, filed a 900-page affidavit out of time. Now, we saw that the respondents argued that if you file this out of time and given the limited time of an election petition, a presidential election petition hearing, it means that we will not have enough time to be able to go through these issues and be able to do justice on behalf of our clients. So, of course, the court must be able to determine in the interests of justice will this have an impact negatively on the petitioner or the respondent? Or the court would look at it and say that this matter is of such gravity that we think, nonetheless, we will allow this out of time.
I'll come to you in a short while, Daktari, but I want to speak to my colleague, Mark Namaswa, who is at the All Saints Cathedral. Mark, I saw a short while ago the principals of NASA, at least some of them, kindly confirm who exactly is there, and is it a special service, or did they just attend a service that was already scheduled?
Again, I can confirm that NASA principals Kalonzo Musyoka, Raila Odinga, and Moses Wetangula are in attendance at All Saints Cathedral. It's not really a special prayer session for them, but they just came to attend Mass here. I can also confirm that Nairobi Women Rep-elect Esther Pasaris is also in attendance. Kibra MP-elect Ken Okoth, Saboti MP on ODM-elect Caleb Amis is also inside All Saints Cathedral for the Mass. Now, outside looking at the ongoings here, it doesn't look like something that is that high profile. You can hardly tell that we have VIPs inside the church. Everything is just running as usual, probably because of security that has been enhanced outside there. But basically, they came here for prayers, and we expect them to speak to us immediately after the Mass is done, then head to the Supreme Court. We understand that according to the NASA program, there was supposed to be a public assembly starting from 10:30 a.m. at the Supreme Court. But you also understand that some roads leading to the Supreme Court have been barricaded. Wabera Street, Harambee Street, and City Hall Way also are out of bounds. So we expect to speak to the NASA principals immediately after this church service and see the way forward, whether they are going ahead with the vigil or not. Remember also, Agel, that they had written a request to Nairobi Police Commander Japhet Koome requesting for the vigil to be held outside the Supreme Court, which was, as far as we are informed, which was declined. So we don't know exactly. It was supposed to be starting from 10 a.m. to 6 p.m. outside the Supreme Court. But as far as we are concerned, the Nairobi Police boss, Japhet Koome, declined that request. So after this service, we'll speak to them and learn the way forward, whether they're heading to the Supreme Court or they're having a change of plans. Back to you, Agail.
So, Mark, you say that they are not in any kind of special service, that in fact they just walked into a service that was already scheduled to go on anyway. But like you mentioned, there is talk that they are part of something that is supposed to go on at the Supreme Court. Do you have any indication when the service will end so that at least we can figure out when they might leave All Saints Cathedral?
The service has begun at around 11:30. It's now 12:30. We are cruising towards 1 p.m. So we expect by around 1 p.m. we should be in the clear on the way forward. But we'll first have to talk to them and see what their plans are. We don't know exactly their programs are at the moment.
So one would expect that at a time like this, in most congregations, there is conversation about the election, about the petition, about what is going on in the country. Has that come up in some form or other, whether it is in some sermon or someone speaking about it? Because most churches tend to talk about this.
Before I walked out, it hadn't come up. Before I walked out about 15 minutes ago, it hadn't come up. But we also have conversations that have been going on around the NASA-affiliated parties' members-elect of parliament, whether they're going to be sworn in or taking the oath on Tuesday or not. They had indicated that they're going to abscond that session. We still wait to see the way forward, because we also informed us there have been meetings between NASA-affiliated MPs elect on, to familiarize with each other and also chart the way forward as a unified front. So we are still waiting to see whether some of these meetings have borne fruit or not, and whether if they miss out on the swearing in, what are the legal ramifications that might face them. So we will shoot these questions to the NASA principals immediately the service is done.
All right, thank you very much, Mark Namaswa. We'll wait for you to do that and just get an update of what's happening there. We'll be going back to Mark Namaswa to talk a little bit about what I call the politics of the petition, because that's clearly not inside the courtroom. And Dr. Musumba, we were speaking about this case and what was going on in the courts yesterday, and you are explaining about all these preliminary things that happen, and typically there would be all these applications that come in. Is there at any point when they become a legal strategy? Can I go to the court like I haven't quite prepared. I say, no, just strike that thing out because we haven't had enough time.
Most definitely. Whatever applications were made yesterday, especially by the parties, have got to be part of your legal strategy. Because you now have had opportunity to look at each other's pleadings. You've read the petitioner's pleadings.
So
the petitioner
you can
has
tell
read,
where they are going with
yes.
it. Yes.
And so you're actually making these applications to look out for your interests. If, for example, the petitioner has said something in their pleadings or made any request or whatever in their pleadings that you think is going to be prejudicial to your own case, now is your opportunity to make a request that is not granted by the court. Similarly, for the petitioner, as part of being able to prosecute your case and be able to carry it on to the best of your ability, you're asking the court to give you, for example, leeway to be able to get further particulars from your opponent. And then, of course, we have the amicus curiae. This is the opportunity granted to them according to the presidential election rules to be able to put in their applications. And I think we do remember that to be able to be amicus curiae, you need to be bringing in a very specific and specialized point that neither party have presented. You should not be bringing in the same sort of claims that are being brought by the petitioner or the respondent. You should be in a quest to educate the court better on particular issues so that the court can arrive at a good determination.
And I'll come to amicus in a moment because there are pretty interesting developments there. But let's talk a little bit about this whole technology thing. I mean, without having to go into too many specifics of this case, but it occurred to me just looking at all the lawyers and even the bench that this IT thing is a specialized area and they were not necessarily experts in what they were talking about. I mean, you would hear some IT experts out here say like, well, that's a bit basic. How does that work? But how do you get that information to have relevance in a case if we are talking about a technical field? For example, if they were talking about something scientific, something medical, whatever it is, how do the judges get the benefit of that knowledge that will then help them to make informed decisions? I mean, no one is going to ask them to go to medical school or an IT school for the next 1 week to be able to rule on that. How does that work behind the scenes?
There are 3 levels at which you can be able to try to make sense of something that you don't understand yourself as a lawyer. And of course, the court itself would require further explanation to be able to make a good determination. Firstly, you as the lawyers in a case, you would of your own volition be able to secure an expert witness who advises you in your chambers or outside of court and is able to point you in the direction that you should be going with respect to a particular matter, whether it's medical, ICT, nuclear physics, whichever. So you have your own. Then you could be able to bring these people to educate the court as expert witnesses where you want them to be able to be cross-examined as well by your opponent. So you could have them as expert witnesses as well inside the court. Then we also have amicus curiae. So if you have, for example, it's an environmental issue, and we have, parties that are interested. Let's say communities living around areas where there's dumping taking place and that sort of thing, and they feel that they want to be represented in court, then they can be able, through an amicus curiae, be able to present their petitions or whatever it is they want to say to the court through that amicus curiae. And that amicus curiae will be able to educate the court as well as educate the others. So in a petition such as this one, where, of course, we don't expect the Supreme Court judges or we don't expect the lawyers themselves who are not experts in this area to definitely rely on the expertise or advice from these experts in ICT in one way or another. So my imagination, and I'm saying I don't know, is that either of these parties will have these people behind the scene. And yesterday we saw one of the amicus curiae applications coming from an ICT association, which if granted by the court, we would expect to benefit from their knowledge and information.
Now, given the fact that ICT is now such a central part of our elections, is there anything that perhaps needs to be done? Do you think that for people who handle election petitions, that this ought to be either very deliberate parts of whether it's training or short courses or whatever? Because I'd imagine that even if I'm going to get information from an expert, I need to have a certain basic level of knowledge that even enables me to ask the right questions. So do you see that as a new area of development in how we handle these things? Because it perhaps would give some confidence, like, wow, these people actually know what they are talking about with regard to this thing that is so important in our elections now?
For sure, I would hope going forward that in terms of what we have in the law itself pertaining to elections, that the law would be clarified further with respect to ICT issues, because clearly they are a very integral aspect of elections today. So for example, I would expect that we'll find some clauses, one or two here and there, speaking directly towards the issue of ICT. If we throw our eyes back to 2013, I think one of the things that was ruled by the court was that the ICT, the ICT element failed. And it was stated that just like any machine or in other aspects that we experience in our working lives elsewhere, ICT does fail. However, when an election is predicated so closely on the issue of ICT, I think we should expect, and this is my own view, that beyond the ordinary failure of ICT, that there needs to be further safeguards to ensure that if we're saying our election is ICT-led, that there needs to be a sense in which we can be able to secure that use of ICT to the greatest extent possible. Mm-hmm. So I certainly would expect some law reform in that area, and then maybe a synergy between lawmakers and ICT experts to be able to clarify that law.
Interesting. I want us to go back to the Supreme Court because my colleague Sophia Wanuna has an update. Sophia, what more can you tell us?
Yeah, good afternoon, Joe. We're getting some important information this afternoon regarding those timelines we were talking about earlier. So we're getting information from the registrar of the Supreme Court that the hearing that was to commence this afternoon at 3 p.m. has been pushed to 9 a.m. tomorrow. The hearing proper of the presidential election petition will begin tomorrow at 9 a.m. And the rulings on the applications that had been made, and that ruling was said to be at 2 p.m., has been moved to 7 p.m. this evening. So 7 p.m. this evening for the rulings on the applications, 8 applications at least on the parties. That's for amicus curiae, for interested parties, and of course the other interlocutory applications that had been made by the various parties, and the hearing proper tomorrow. In as far as the key issues that will come before the court for determination, because we still don't know what those are, we understand that all the parties will be allowed to submit, to present written submissions on the issues. Say, for example, NASA, the petitioner, had presented 24 issues for determination. So the other parties, the respondents, can present written submissions on their misgivings or their support on whatever issues they want to actually come before the court. So we will wait for the timelines in as far as when the submissions are supposed rather to be presented here at the Registry of the Supreme Court. But that's communication coming from the Registrar of the Supreme Court, Esther Nyaikai, and it will be officially sent out in as far as a notice is concerned to the media houses. Joe.
So, Sophia, if I understand you correctly, you're confirming that there will be no ruling on anything at 2 p.m. today. There will be no hearing at 3 p.m. today. That, in fact, tomorrow is when the hearing will begin, but we'll have the ruling 7 p.m. today, you said?
Yes, exactly. 7 p.m. today, ruling on the applications, and then tomorrow, 9 a.m., the hearing proper begins, which, in essence, now we see the judges appearing to agree with those prayers that were being sought by the petitioner and the first and second respondent who had requested that the hearing begin on Monday to allow for everyone to just realign their submissions and their preparations ahead of the hearing. So it looks like finally they've gotten their way. And for those who want to go to church...
Sophia, I was going to ask about that because last night the judges were very firm about these timelines, and I mean many of the lawyers in that courtroom had requested for exactly the same thing, but I remember the Deputy Chief Justice in particular was very firm on that the judges have very little time, that postponing this thing to any other day would have taken from the judges' time. Do we know what has occasioned this change? What are you hearing?
What we're hearing is a lot that we also heard from Paul Muite, who's the lead counsel for the first petition. I remember he said everyone is cognizant of the strict timelines, because that is what the Deputy CJ was talking about, and that they needed more time because there's also that demand for an actual written, complete judgment when they finally deliver their judgment. But remember, Paul Muite talked about if they're allowed to begin hearings on Monday, they would move faster, because then everybody is ready. There's, everything that needs to be ironed out has been, and really they can just come settled and prepared to kickstart the hearings and the proceedings. However, you remember, of course, the agreement at the time was 3 p.m. So it appears that kind of thinking, even on the part of the judges, has carried the day, because all of these even decisions they must make, decide on the actual questions and matters that will be coming before them, it's a lot of work. It requires time to actually just weigh into that. And we're seeing even with the actual questions that will come for submission, they're now asking the parties to weigh in, to present written submissions on the questions, in essence to argue out what their misgivings or issues or concerns are, with the perhaps numerous prayers, as have been described by some quarters, coming from the petitioners, 24 in total. So, Joe, that kind of thinking that perhaps prepare better before you come for presentation will make for a better, speedier, clearer proceedings, Joe.
So, Sophia, I'll be asking you one more question, but just hold it there, because I would like us, our viewers, to have a look at, listen actually to what the judges were saying last night with regard to this particular question on the timelines. Watch.
What time you want us to start hearings tomorrow? Because we do propose that we start hearings tomorrow. What time is suitable to the chaplain of the Anglican Church and the rest of us who want to go to church tomorrow? So what time is suitable?
My Lord, I was praying that after you give the rulings tomorrow, and that's subject to the times that the court could allocate, that the substantive hearing will start on Monday. And tomorrow we come and get the rulings. They may have an impact on how you plan our presentations. And also, it may allow Paul Winter to go to church.
The thing is that we only have 14 days within which to hear and determine. Of the 14, 8 is gone, and we cannot afford to lose a minute. So we must, of necessity, start the hearings tomorrow. It is the time that I want to get consensus from that end about.
I was going to plead that actually we would move much faster from this side of the bar if we were given tomorrow to do our respective restructuring and preparations. I think we would then move a lot faster, and we could start as early as Monday at 9. And really, we appreciate everybody here is conscious of the fact that obviously the judges are also human. We cannot expect you to spend the whole day listening to submissions by counsel and then go and spend the night writing the judgment. You need time. So we're pleading, if the bar could have Monday and Tuesday, and then leave the bench with Wednesday and Thursday, we would really move a lot faster.
Counsel, we have not complained. You have had time since the 18th, or indeed since the 11th, when these results were declared, to plan your cases. And when you talk about getting an extra day, you're taking that day from us. And you're the same people who have been saying You do not want a 1-minute ruling. So do not have mercy on us. We haven't been sleeping the last few days and we are still okay. And since we are not complaining ourselves, we are mindful that we must finish this matter within 14 days. We are mindful that what we give you on the 14th day is something that makes sense.
So a very resolute Deputy Chief Justice there talking last night, but as we understand right now from our reporter, Sophia Wanuna, that has now changed. Sophia, do we have any idea where these judges have been, where they've been spending their time since last night? Are they somewhere around the courts, perhaps in their own private residences, where they've come up perhaps with this to this conclusion that this is not going to happen today?
It's unclear where they are, but we can report they are together at this point. We understand the registrar of the Supreme Court alongside all the 7 judges are caucusing, and that is where this decision has been reached. So they're not making known where that location is, but it's not here at the Supreme Court for sure. But they are caucusing together to be able to just iron out as they deliberate on the other issues ahead of that sitting that now we understand will be taking place at 7 p.m. to rule on the applications, Joe.
Thank you very much, Sophia Wanuna. We do hope that we can get some reactions from those legal teams about this latest turn of events in the courts. But yes, as Sophia mentioned there, the ruling that was supposed to happen today at 2 p.m. rulings, I should say, because on a number of things, that has been pushed to 7 p.m. That's this evening. And then the hearing proper of the main petition will begin tomorrow at 9 a.m. So the judges there perhaps doing a reality check and effectively granting the wish of most of the council last night. Martin Olo, if you're on phone still, Martin Olo is a lawyer. What do you make of this latest turn of events at the courts? The Supreme Court judges basically saying, well, we will start this tomorrow, 9 a.m.
Joe, I think that this is realistic. Realistic in the sense that they have weighty issues before them. They have several...
Just call back when you're ready.
And next rulings over. So they need to think through and reason through those, as the court said yesterday, that they must reason through everything. So asking for a little bit of more time, or indeed buying more time, is necessary if they are going to get to the best of this. And also remember that most of the council yesterday, just as Sophia when I was saying earlier, were of the view that they needed a little more time to prepare better and to begin to articulate this. Of course, we have a time constraint, and everybody needs to work with the time constraint in mind, but not as a sacrifice or not at the altar of quality. So what we are seeing is that there is both an attempt to give people time to work through things, and also to ensure there's quality even in terms of the rulings that the judges are supposed to give, and that there's quality in terms of submissions that we're expecting the council to give. So I think this is a good idea.
All right. Thank you very much, Martin Olo. Obviously, this is something that we'll be following very closely. Right now, I want us to take a break. I'll be coming back to speak to my guest here, and we'll be joined by 1 or 2 more guests within the course of the next hour. But right now, my colleagues, Michelle Ngele, will be coming up with a news update, and then we'll be back here to talk about what we can expect tonight.